20 DM 354. Beginning with petitioner, if appearances could be announced, please.
Your Honor, may it please the court, Desiree Smith appears on behalf of the petitioner, Brandon Daugherty, who also appears. I also have his wife, Rachel Papst, with us.
Very well.
May it please the court, the respondent, Cassie Hall, appears with counsel Jessica Levitt.
Have you entered your appearance formally in this case, Ms. Levitt?
Yes, I have, Judge.
All right. This matter comes before the court at this time for further proceedings. A proceeding was conducted in this court on April the 6th. Desiree Smith appeared with Brandon. Cassie Hall appeared pro se on that date. The court determined that on the hearing for emergency motion to restrain the father from having contact with his son, the court found insufficient evidence before the court to warrant any such orders. There was a Sedgwick County PFA case with other petitioners, was to be heard relatively soon after that date. The court ruled that the father still had on every other weekend unsupervised visits. Court ordered allowance of child therapy at the Sunlight CAC. And the court would conduct a review of this case today.
All right, guys. The courtroom opens with a familiar but serious issue, parenting time. The judge begins reviewing the history of the case, immediately revealing that the father was previously accused in an emergency motion meant to restrict contact with his son. But the court already found insufficient evidence for those claims. That sets the stage for today's hearing. Right away, you can sense that both sides are preparing to defend their decisions, and the judge is stepping in to figure out what really happened.
Ms. Smith was directed to file a journal entry of those proceedings. Ms. Smith, how do you perceive the current status of this?
Your Honor, the PFA has been set for trial on May 7th. So it was originally set for a docket day where we didn't have sufficient time to do a trial. And so at that date, it was set for a trial date of May 7th. So the PFA has not been resolved yet. Findings have not been made in favor of either party, just moved to a trial date. As far as the journal entry, it is being finalized. I don't think I've gotten it over to the respondent yet, but it should go out today. Getting that finalized. We had an issue with parenting time over weekend where my client was denied parenting time despite the court's orders. And then I believe there's also a pending motion from the petitioner to modify custody with just a regular motion today, which my client objects to.
All right. I'm not aware of the most recently filed motion. When was that filed?
Your Honor, it was filed at the same time that her emergency motion was filed. And that's how we ended up here today. So I believe that motion is before the court today. That was kind of how we got back here.
Is that motion still being pursued, Ms. Levitt?
Your Honor, the motions are kind of tied together as an emergency motion and a regular motion, which of course the court did not grant emergency orders. And yes, at this time, the motion is still being pursued. Unfortunately, I do think that the continuation of the PFA and the fact that therapy is...
Now the lawyers begin laying out where things currently stand, and it becomes clear that this situation is far from resolved. The protection order case is still pending, meaning tensions are already high between the parents. On top of that, the court learns that a dispute happened over the weekend when the father was allegedly denied his parenting time. When a court order says a parent gets time with their child, blocking that time can become a serious issue very quickly.
Just started does put quite a hurdle in our pathway in being able to fully resolve what's pending before the court.
So what do you propose we do here, Ms. Levitt?
Yes, Your Honor. Well, I will tell the court that since there is no journal entry from the last hearing, and I will apologize if I'm wrong on anything that the court said from that. My client tried to convey to me as accurately as possible as what occurred. And it would seem that at the last hearing, one thing that was made clear by all parties is that there's a fair amount of co-parenting issues between the parties, communication issues, that they are following a parenting plan that is not the same as their written parenting plan, and that there are questions about what is going on in dad's home, what is appropriate rules to set, can mom have a say on certain things or not, or know certain things or not. And those are all issues that we tend to explore in alternative dispute resolution, or in another form of that, such as co-parenting counseling, when the parties have such a high level of conflict as these two parties have. And I think that unless the court intends to dismiss the respondent's motion, that alternative dispute resolution is literally designed for what these parties have. They previously did mediation with Joy Marlin at Midland Mediation that resulted in them successfully settling their custody issues in the divorce. I have successfully used retired Judge Mike Powers to do mediation, and he does it at an incredibly reasonable rate, $900 for an entire morning 4-hour session to resolve issues. And he'll.
Things start getting deeper as the respondent's attorney explains that the real problem here isn't just one weekend. It's an ongoing breakdown in communication between these two parents. They're following a parenting routine that doesn't even match their official parenting plan anymore. That's usually a sign that the situation has drifted far from what the court originally intended. So the attorney suggests something courts often push in high-conflict cases: mediation.
Explore everything from co-parenting issues to parenting time and child support. And Micah Gross provides co-parenting coaching in which, if the parties reach agreements regarding co-parenting communication or parenting time issues, she is, agreeable to sending that on to counsel for counsel to memorialize. I don't think these parties are going to resolve their problems between each other. I think the court probably got a pretty strong flavor of that at the last hearing, and things have not gotten better. I can delve into some of the issues that have gone on since the last hearing if the court wishes me to do so.
Such as your client's denial of parenting time to the father?
Yes, Your Honor, I can address that. On
Please
the
do.
18th, I'm sorry, my volume is too low. Could you repeat that, sir?
Please do explain
Okay.
it.
Yes, Your Honor. So on the 18th Friday the 18th would have been Mr. Daughtry's next set of parenting time after his 2 weeks prior. Every other weekend is his current schedule. And my client made a request in our family wizard that day prior to the exchange that he let her know where he was exercising parenting time, because she had been informed by the parties who have filed a PFA against Mr. Daughtry that their children were at parenting time with their mother and that Mr. Daughtry couldn't be there. He refused to provide that information. I had just been retained in the days leading up to his parenting time. My legal assistant was out, so my interim appearance was pending, but not filed in E-Flex. So I called Ms. Smith's office to speak to her directly about the issue. Long story short, there was some communication and confusion about who to speak to, and the parties had a conflict over whether.
Here we finally hear the mother's explanation for why the child wasn't handed over that weekend. According to her side, the father refused to say exactly where the child would be staying during his parenting time. That raised alarms for her. She claimed she simply wanted to know where her child would be sleeping and felt it was a safety issue. In custody cases, that kind of information can become surprisingly important.
Mr. Daughtry had an obligation to tell my client where his parenting time would be. That conflict occurred in the Augusta police station. There was no police officer available to make any report on the same. As my understanding, there was just a clerk at the front desk, so to speak. And my client made the decision that Mr. Daughtry refusing to provide his address and the child being sick, having medication that had to be refrigerated, she did not believe it was safe for the child to go to parenting time. Following that, we received a return of service from the Butler County Sheriff's Department stating that they could not serve Mr. Daughtry at the address provided by my client in her motion to serve him because he now resides at an address in Goddard, Kansas, 944 Long Path Circle. What's interesting about that address, Your Honor, is that's not an address my client has ever received from Mr. Daughtry. Their parenting plan specifically states that both parties are to provide the other their current residential address. My client believed he lived at an address in Wichita. We knew that he was not allowed to be at his address in the PFA if his apparently now wife's children were present. She asked these questions. He didn't provide it. He believes that he only has to provide what he is stating as his permanent residential address, which is not what the parenting plan says. It says current residential address. And yet, when being pedantic and trying to split hairs over what the parenting plan says, we find out from the sheriff that he's not even providing the address where the sheriff knows him to live. We've also had issues since that time that Mr. Daughtry has recorded.
But the situation gets even more complicated. The attorney explains that when authorities attempted to serve legal paperwork, the father couldn't be found at the address provided. Instead, a completely different address surfaced. That immediately raises a question in court. Did the mother truly know where the father lived? Or was the information unclear all along? In custody disputes, confusion about living arrangements can quickly turn into mistrust.
Reported the minor child while he is interrogating him about mom's house. The child reports that one time he was questioned in the bathtub, another time he was filmed the entire time, another time he was questioned just at the residence. Once was about questions about mom leaving him home alone, which the child had said he had had a dream about his mother leaving him home alone, and there was our family wizard communication between the parties about that, where Mr. Daughtry had said, hey, Easton was telling me about this dream that he had where he was left home alone at your house. My client said that's never occurred. Sounds like he was scared about the dream, kind of essentially like, sorry to hear it, that's concerning, but it's never happened. And then he also asked the child another time to explain to him about how mom's house caught on fire. Miss Hall's never had a house fire. So he's been recording the child during parenting time. He's also filed a DCF report against my client. DCF has already come out, and that DCF report was that my client has left the child alone in the home. My client shared the Our Family Wizard messages with the DCF social worker, who said, okay, this is clearly a custody issue. You guys are already in court for this. I'm not doing anything further. And so there is just a ratcheting up of conflict. My client fully owns the decision she made on the 18th in regards to parenting time. She believed that that was a safety issue for her child, concerning that she didn't know where the child was going to be. She feels that Mr. Daughtry is entitled to the same information about her during parenting time if her parenting time is not occurring at her residence. She believes that that is what joint legal.
Now the accusations escalate. The mother's attorney claims the father recorded the child during conversations about the mother's home, even questioning the child about dreams and situations that may never have happened. On top of that, the father allegedly reported the mother to Child Protective Services, but the investigation didn't go anywhere. At this point, the judge is hearing a picture of two parents locked in constant suspicion.
Custody entitles the parties to know about the child's safety and well-being. But the other issues, the DCF reports, recording the child, asking the child about mom's home, creating a false narrative about mom's home, these are all issues that are not going to go away and that need some outside input or influence, or the court could set the matter for trial. But I don't think I think that just continues to ratchet up litigation and anger between the parties and doesn't teach them the right way to co-parent, which both parties need. I will say that as much about my client as I will about dad. Both parties have never learned how to co-parent in this case.
Very well. Ms. Smith, your client's reply to this argument that's been made?
Yes, Your Honor. Your Honor, my client disagrees with the characterization of his residence. The address that is on the return of service was his address prior to him moving in with his now wife, and he lived there for quite some time. It's his position that the respondent was well aware of that. There were several months, if not a couple of years.
Actually, the 215 Eureka address, I haven't lived there for years.
Yeah, so that's the address that she sent it to was in Eureka. The address that the sheriff said he now lives at was a previous address that he had before he moved in with my client, and so, or with his wife. So she had knowledge of all of those, and she chose to send the notice of service to an old address that he hasn't lived at in a long time. Regardless, he's now appeared for the hearing, so the issue of service is not at play, but he denies that she did not know about that address.
Father's attorney steps in to respond, pushing back on the claims about the addresses. According to his side, the mother already knew about the previous addresses and had chosen to send legal paperwork to an outdated one. Meanwhile, the father insists his current residence is stable and shared with his wife. In these cases, the smallest details, like which address someone used, can suddenly become major courtroom arguments.
And that she was very well aware that he had lived there at one point in time, and she's very well aware of what his current address is now. He did decline.
What is his current address? I presume he has one?
Yes, can you state the address?
1913 Covington Street, Wichita, Kansas.
And that's the address he shares with Miss Pabst. They are married, they reside at that address. Now, it is true because...
So when he was asked for his current address and where the parenting time was going to take place, why didn't he just tell her that?
Your Honor, he did, that is the address she has, but he's not allowed to be at that address when her kids are there because of the pending PFA. So if her kids are at that address when he also has parenting time, when those parenting times overlap, he has to exercise for this 3 weeks of time, he has to exercise his parenting time somewhere else. And so that I think was the issue, is that she wanted to know exactly where he was going to be during his parenting time, since he couldn't be at the permanent address for parts of it because her children were there. And he chose not to share that because of a PFS that has happened before between the two of them and an aggravated assault charge that has happened where Ms. Hall has actually ended up putting him in the hospital because of injuries that she caused to him. And so he did not feel safe sharing an address that he was going to be at, due to the fact that she is communicating closely with Ms. Papp's ex, who is running the PFA, and they are using it to harass them and send people to sit outside their houses. And those
The defense also explains why the father didn't want to reveal exactly where he would stay during parenting time. They claim there is a history of conflict and even allegations of violence between the parents. Because of that, the father felt unsafe sharing temporary locations where he would be staying with his son. In other words, what one parent sees as secrecy, the other sees as protection.
sorts of things. So he did not feel comfortable sharing where the temporary address was going to be, nor did he feel that that was required by joint legal custody, as it is not his permanent address. He has not moved. He just simply has to exercise portions of his parenting time away from the address when Ms. Papp's kids are there. He still lives there. He doesn't plan on moving. We plan on resolving the PFA on May 7th. So this is 2 weekends that would have been affected by his inability to be there. Yet despite me explaining this to both opposing counsel and the respondent before, I knew she had counsel, she still chose to withhold the child on Easter weekend instead. And so my client doesn't disagree that the communication between the parties is a problem. For example, in that she also said that he had an ear infection, and she did not tell him when she took him to the doctor for that ear infection or that he was prescribed medication until a few minutes before drop off. So she is also not informing my client of medical appointments or diagnoses or outcomes for the minor child. So these parties do have a problem communicating. I believe they likely both blame the other for that. But my client doesn't feel that he should be denied parenting time at this point and would request makeup parenting time for the weekend that he missed. As far as
if it was the intention of your client to just simply take the boy and live under a bridge in Wichita in a tent for the weekend, the mother is supposed to tolerate that?
Your Honor, my client had told her that he had a safe place for them to be, and that was
why
not the
not?
situation.
This is where the judge steps in with direct questioning. He asks a simple but powerful question. If the father had a safe place for the child, why not just say where it was? From the court's perspective, transparency could have prevented this entire conflict. Judges often look for common sense solutions, and here the judge seems puzzled that such basic information wasn't shared.
But I still don't understand the reason why he wouldn't just simply tell her, look, I can't go to my regular house right now because of a conflicting court order, which you know about. We're going to be at this motel. We're going to be at this place. We're going to be staying here for the weekend. Everything's cool. And that's what I don't understand. Because of some past history between those two, he can't give her simple information as to where their son is going to be?
Your Honor, the past history did inform his decision because she's committed domestic violence against him before, and because recently with this PFA, she has been sending people to sit outside the residence and film him and the minor child. And so he has some pictures and photos of that. And so he did not feel that it was safe to share information of where he would be. And he believes that she was using that information solely to provide information to Ms. Papp's ex-husband in the PFA case, which is another problem, that she's involving herself in a case that she is not involved with.
All right. Having heard from both parties, two observations. Number one, the father's reticence, in fact, refusal to inform the mother as to where the boy would be during that weekend was wrong on his part. She has a right to know where her son's going to be. Now, if she acts out from that and does some improper things after obtaining that information, that's on her. but the father should have disclosed to the mother where the son was going to be. With that said, it was wrong for the mother to deny the visit. Presumably, Mr. Doherty is going to always look out for the...
Now the judge begins delivering his observations, and he doesn't let either side off the hook. First, he tells the father that refusing to disclose where the child would be staying was wrong. The mother has a right to know where her child is. But the judge immediately follows that with another point, denying the father his parenting time because of that was also wrong.
Interest of his son. I'm going to presume that he's not going to be reckless enough to sleep under a bridge in Wichita in a tent. That he's actually going to have some sort of substitute shelter arrangement for the boy. Should have disclosed that to the mother to just end that controversy. But I would presuppose that he's going to care for his son during his time. So I think it was wrong for the mother to unilaterally make a decision. Well, since you won't give me information, you don't get our son. That's wrong. If he has his parenting time set up for a certain weekend and the father wishes to exercise it, it should go through. And if there's some instructions that need to be given about medicine for an ear infection, then the father ought to be informed and he needs to make sure that his son gets his medications. I think that the father should be very capable of taking care of that during his parenting time. So the court's going to order the father to have substitute parenting time for the weekend he missed. As far as the scheduling of that, it will depend on the rotation. I'm going to give the father some latitude here as to what weekend he wants to make it up. But I believe that he should have an additional weekend with his son for the one that, in the view of the court, was wrongfully withheld from him. But with that said, Mr. Doherty, I do understand that you don't want to violate a Sedgwick County court order. I don't understand why Sedgwick County can't move the case through the system more efficiently than this one apparently is. But as long as that order's on you, you need to comply with it. But you should tell the mother where you're going to be staying that weekend. And then I expect the mother to stay out of it from there.
The judge makes it clear that parenting time ordered by the court isn't something one parent can cancel unilaterally. Even if communication breaks down, the proper response is to bring the issue back to court, not block the visit altogether. As a result, the judge rules that the father will receive make-up parenting time for the weekend he missed.
Ms. Smith, since this is an order generally favorable to your client, I'm going to expect you to draft it
Yes, Your Honor.
for the makeup weekend with the date that's been decided upon. All right, what's your view regarding alternative dispute resolution here, Ms. Smith?
Your Honor, I don't think that's something that's just mediation with just the two of them with Joy Marlin is going to be successful. If we wanted to do a mediation with a third party with attorneys present, that could be an option. The other option would obviously be to do domestic conciliation, which may inform the court some more of some of the issues. My client is open to either of those. But I don't think that just the two of them with a third party mediator is going to be successful. I believe there's going to have to be either a domestic conciliator or attorney involvement in that process.
Who would you suggest be this domestic conciliator?
In Sedgwick County, we generally use either Alex Flores or Christy Campbell. Christina Ratzlaff has done a couple for us recently. I think any of those would be options. I'm not sure what their schedules are. I don't know if there's any that are currently practicing primarily in Butler County right now.
All right, Ms. Levitt, I'm comfortable with any of those three names. I'm familiar with all three that she mentioned. Do you have any preference or do you have any concerns about any of those?
With that decision made, the discussion shifts toward solving the bigger problem, constant conflict between the parents. Both attorneys agree that communication has clearly failed. The court begins exploring alternative dispute resolution, essentially bringing in a neutral professional who might help these parents work through their disagreements before they spiral back into court.